Hi, I'm Gary L. Zerman. I'm an attorney. I live in Valencia, California. I'm a member of the California Bar since 1984 and also a member of the Arizona Bar, State Bar. I was born in Columbus, Ohio. I grew up in Sarasota, Florida. I ended up starting at Manatee Junior College. I went into the Air Force. I was a security policeman with a specialty in law enforcement. I served a tour in Vietnam and Thailand, came back and was discharged from SAC headquarters in Omaha, Nebraska, off of Air Force Base. I then went back to junior college, got my degree, went to University of West Florida, graduated in management, worked for Burroughs Corporation in computer sales for about a year, and then I came out to Southern California to go to law school at Southwestern University School of Law. I got into the law because my dad was a custom home builder in Columbus, Ohio, and had built a house for a doctor and for a lawyer. In fact, the lawyer was the dean of the Ohio State Law School. And certain things were added onto the house. My dad bought the materials, did the labor, but when it came time to get paid, these two pillars of society told him, oh, we thought that was part of the contract. And I never saw anyone that worked harder and that was more honest than my father. And I thought I was going to go into building myself, but I said, if my father works that hard and is that honest, but then gets taken or screwed out of his due profits and earnings, I better go to law school. And so that's why I went to law school. And then I found the law very, very challenging, but I found it has been exponentially outweighed by the frustrations and the lack of integrity that I've run into. I started out clerking for a law firm right across from our law school. Southwestern is located in Wilshire Boulevard, and in fact it's now has purchased Bullock's Wilshire, and that's a national depository for a lot of government laws and books, and so that's their library now. They've taken over the Bullock's Wilshire, and it's a good law school. It puts out a lot of attorneys, and there's a lot of judges in this state from that school. I found my law school career or schooling a little frustrating. I won't get into that at the moment. But I started out clerking in my second year for a law firm that did insurance defense. And I liked that because you got a variety of cases and you got to learn in every case about medicine, about engineering, and various other things. So you were always learning. But when I started clerking, it would have been in the year 1980, and just shortly before this time, there's mammoth changes that were happening in the law. In California, in the 70s, the state bar doubled, but nothing really happened regarding the state bar administration. So you had a massive backlog of cases, and eventually so many of them just got dismissed because the bar wasn't doing its job. Another problem was that the law became a one-way ratchet during this period and sometime before, and there's a lot better ways to solve things than through lawsuits. There's a really good book called The Litigation Explosion: What Happened When America Unleashed the Lawsuit by Walter K. Olson. He's a very, very good scholar that writes critically about the law, and I'd recommend that anybody look at his books. And so the law was just greatly expanding at this time, and there was no apparatus there to do the proper balancing and discipline that it needed to be there, and it just took off wildly. And I think it's only gotten worse since that time. After I graduated, I became an associate attorney at the firm there, and then worked at several other insurance defense firms where we did major product liability lawsuits, particularly automotive. And there were some really big cases up against some big firms. Then we also did government tort liability. And most of the things that I saw were generally, you would say, somewhat honest and had integrity. Of course, there's always been tinkering around the margins, but I saw a subtle change where just lying started to happen and perjury was occurring down in court. In fact, there's an amazing bar report I have in California as to what I was talking about earlier about the number of bar complaints that build up. And I'm trying to think of the exact date, but a professor, Robert Felmuth, was appointed the special discipline monitor for the bar. By statute, he had a 4-year term, and he would come in and do periodic evaluations and reports. His term was for 4 years, and so he did 4 reports a year. When he first came in, he said the bar is to be somewhat congratulated because they have an 8-number hotline number for the public, especially people that had attorneys and have a problem with them. But in every report, he said, he also criticized them. Although they had the number, they didn't expose it anywhere. And that remained a complaint throughout his reports until the final one. And his final report is quite critical. He says that perjury is rampant in the courts and nothing virtually is done about it. I did insurance defense, and then I got into plaintiff's legal malpractice. And that's when I got my real legal education and got my head handed to me at the same time. That's when I found out what the law was really like and came to the conclusion that people think when you go to court it's about truth and justice. And I found out it was more about power and money. I had a big legal malpractice case against 2 prominent attorneys, and I'll get into that in a minute. Many people may have heard these names. It's Brown, Green, and Melvin Belli. And I won't get into many of the details about it, but when I went to court, the main thing in the case had to do with a conflict of interest. When I came in, it was a 3rd-generation lawsuit. The first one was product liability that Mr. Green had, and then Mr. Belli came in and sued Green for malpractice. And then I think improperly also took over the appeal of case number 1, magnifying the conflicts. I came in and sued both attorneys and said both prior lawsuits ended up in irregular proceedings to the clients because the attorneys never recognized the conflict of interest. And the conflict was that they were in a single vehicle product liability accident that had to do nothing with charges of stability of the vehicle that turned over and caught on fire. The allegations had only to do with a defective fuel system, that they were representing both the driver and 2 negligent-free passengers in that lawsuit. And it was for both the injuries to the driver and the passengers as well as a wrongful death because there was an 8-day-old baby in the vehicle who went out the window and was crushed to death by the vehicle. So the baby wasn't involved in any of the fire allegations or the defective product allegations, and right away any competent attorney would think that there's a conflict here because the driver probably killed the baby. The coroner, right at the time of the accident, came out and said the baby, in his examination and based on the evidence, that the baby was found under the left door and had no soot in his trachea and had a crushed skull. So the baby had a crushed skull and died before it had breathed any of the fire and had been dead. So that was a conflict of interest, and these attorneys ignored it. They were even told about the conflict. And in California, the law, and there's particular cases that say that certain conflicts can't be waived because they go to the credibility of the attorney standing in front of the jury. And you just can't present certain cases because the attorney has to stand on both sides of the fence and his credibility before the jury will be compromised. Moreover, in certain conflict situations, the attorney has to apprise the client of the conflict and advise the client that they can seek the advice of another independent attorney, and has to get that client's written consent in writing. Well, in this case, both of the attorneys ignored the conflict. But when I had case 3, I knew that there was really trouble when I first had the case because of the way the judges were ruling on it. Mr. Fine, Richard Fine, has given his interview here earlier today, and one of the judges that I had that denied the summary judgment was a Judge Yaffe, and I think his conduct is suspect regarding that, because this case that I had, I don't want to say it was a slam dunk, because what I know, there's nothing slam dunk in the law. And see, the purpose of the law is to give us clarity, give us a certain degree of certainty. And when I analyzed this case, all you had to do was determine that there was a conflict of interest, and then the elements in the case fell in our favor like dominoes, because a legal malpractice case is very similar to a basic negligence case that has 4 elements. The first element is a legal duty. The second element is breach of duty. The third element is causation, and the fourth element is damages. Well, clearly these attorneys represented these people, so they had a legal duty. And that duty in particular then, or more particular, would be to advise of the conflict. So we established legal duty. The first 2 elements, duty and legal duty, are legal questions for the judge, and causation and damages are jury questions. So clearly there was a legal duty here. They were their attorneys, and they had a duty to apprise them of the conflict. We win on breach of duty because it was the testimony of both Mr. Belli and Mr. Green, or Mr. Green in the first case and Mr. Belli in the second, that neither of them had apprised them of a conflict, because they both said there was no conflict. Then we win on causation because we have negligence per se. They had violated a rule of professional conduct, and there's a famous case in California called Day versus Rosenthal, and that Day is Doris Day, and these rules in certain cases cannot be controverted. And that was the situation in our case. So clearly, there's no evidence that they could put on to contradict that. And also, there's a case in California that says that that's fraud upon the client, the failure to notify them of a material fact in their case. And then number 3, we win on causation, because in the first case, the clients were apprised that the defendant had made, the vehicle manufacturer, Ford Motor Company, had made a $2 million offer. And there was a question in the first case whether that was ever communicated to the clients, the fact that $2 million had been offered. Moreover, even if you could communicate it to the clients, how are you going to explain it? Because there's a conflict. There's a potential that the driver, in fact, was the sole proximate cause of the accident. And so until the other 2 negligent-free passengers are made free, the driver doesn't get a penny. In fact, the driver shouldn't be sitting with them at trial, and they were, and that's how they end up losing the case, because the jury came back and found against the plaintiffs on all causes of action. The defendant won, and they got 0. And then in the second case, Melvin Belli came in and represented the exact same conflict, didn't apprise them of that, and ignored it. And then also he took over the case 1 appeal, and it could be argued that's a conflict because he didn't want to do a good job on the appeal, because if he prevailed on the appeal in case 1, there would be no case 2. And it would be harder to retry a big product liability case rather than the legal malpractice case that he took. And again, in that case, Belli did not apprise the clients of the conflict of interest that can't be waived, and violated his duties. But on top of that, they were offered $550,000, and he informed them apparently not to take it. They didn't take it. They went to trial. There may have been some errors in the trial and some shenanigans that went on, but they got skunked in that case too. So that's when I came in and said that, wait a minute, how could these 2 cases, I think case 1 went through the hands with, or no, through both cases, they went through 14 judges, and no one recognized this conflict. So when I came in, again, I made a motion for summary judgment, and Judge Yaffe denied that. Then we went to trial, and the judge I had was a guy by the name of Henry Patrick Nelson. And unfortunately, the firm I was at the time had an outdated profile on him, and it didn't look too bad. The current one would have been that he had been kicked out of criminal and was on the last legs of his tenure in civil, and was probably one of the most complained about judges in the state. In fact, he was rated one of the 10 worst. But since the firm I was at didn't have that information and hadn't had the old one, I wasn't apprised of that and took him. And from the moment I walked into his courtroom, I thought this wasn't going to go well. He was really irascible. He was a black judge, and I saw him taunt a black criminal defendant in there. He was finishing up a case. It was actually horrible to watch that. It was a sentencing matter or probation matter, and he actually was taunting him. And then another incident happened is he was a tyrant. And what you usually see is if a judge is a good person, his staff will pick up his demeanor and act like him. And conversely, if he's a SOB or a tyrant, he treats his staff that way, and they're going to treat other people that way. And there was one incident while we were down there, while somebody came into the door and let the door slam a little bit. It really didn't make much noise. And he jumped all over this young woman dressed professionally. And what was amazing is you saw how his demeanor changed when he found out she was a current prosecutor. One of the reasons he was kicked out of criminal is because he, I believe, was blanket affidavitted by all the prosecutors. And I would also say that not only was he corrupt, he was also stupid. Like the case I had, he didn't even have knowledge that the guest statute had been repealed in California. And what the guest statute was is while tort law was developing regarding contributory negligence over to comparative negligence, states had laws that if you were a guest in someone's car and you got into an accident and it was the driver's fault of the car that you were being in, you couldn't sue them because there was too much a potential for fraud. In California, that was ruled unconstitutional under a 1975 case called Lee versus Yellow Cab. And when I was trying this case, this Judge Nelson had no idea that that was the law. So anyway, what happened is I started to give my opening statement, and he stopped me and said, "Only I can talk about the law." And I said, "Well, excuse me, Your Honor, this is a legal malpractice case." It'd be something like in a dental malpractice case, I couldn't tell the jury about dentistry. Well, I don't know how I'm going to put on the case and inform the jury about the case and put on evidence. So anyway, he ordered me to sit down in my opening statement, and this was at a bench conference, and I said, "Well, Your Honor, what do you want me to tell the jury?" And that was kind of a two-phase question. Number one, it was general, like, what do you want me to tell them if I can't talk about the law? But also I inquired, well, what do you want me to tell them about you sitting me down? And he just said, "Sit down." So then the other side had an opportunity to make an opening statement, and then it was our turn to put on the case. And so even in these pretrial matters, he never held a pretrial conference, which any competent judge should do, is invite the attorneys in to his chambers and ask, is there any way that we can settle this? Is everything ready to go? And just a competent judge would do that to get things rolling and eliminate a lot of things that may come up later. He had nothing like that. So then I attempt to put on the case, and he's browbeating me and making sarcastic comments from the bench. Let me back up for a minute. This was a jury trial, so we had picked the jury, and I thought we had a pretty good jury. And so as I'm putting on my case, some of these judges are pretty skilled, and especially if somebody's in pro per, And when you're arguing your case, especially if you have a jury, the judge is skilled in making it look like you're arguing with him, and that kind of alienates the jury. And he also did that with me here. And so we attempted to put on our case, and after about a couple of witnesses, a couple things happened earlier. One, I had a subpoena for Mr. Belli, and he wouldn't honor that. I also had a subpoena for Mr. Green, and he wouldn't honor that. And I had an assistant call Mr. Green to see where he was, and we were informed that he's on the phone right then talking to the judge. This was after hours, after the first day of trial. And that's improper because that's an improper ex parte communication. And I waited till the next day and we started up, and of course the judge didn't put that on the record. So it's going really difficult as I'm trying to present my case, because I can handle the other side, the defense attorney, but you expect to have an impartial, fair judge allow you to, who will follow the law and be fair to both sides, but he's beating me up and hammering at me one side and down the other. And then we come back from lunch after one witness, and I could tell that something had happened, and it appeared that they had met. Again, it would be an improper ex parte application because they're all on the same wavelength, and what they've decided is this case is over. Because we come back and he asked me, do you have any evidence that the driver had any money? And I said, no, Your Honor. That has been our position from the beginning, but it's also our position that it's largely irrelevant. And he says, well, this case is over. And he says this in front of the jury. This case is over. Jurors, no attorney would bring this case. Jurors go into the jury room and fine for the defendant. Well, he can't do that under the law, but he can do that if he abuses his power. And so I was hoping while that happened that while the jury was out, someone would remember something from their junior high or civics class, that the judge can't do that, that my clients and I were entitled to our day in court, were entitled to a trial. But unfortunately, they obeyed the judge and acted like sheep and did what he said. And let me back up then, you know, as to this case, this judge did find that there was a conflict. And that's important then because, again, all of the elements in the case, duty, breach of duty, causation, and damages, fall in our favor. Now, those are the elements of a basic negligence case and a professional negligence case. The difference in a professional negligence case is sometimes you need an expert witness to come in and talk about the standard of care. Well, we didn't even need to do that in this case, but in fact, I had two highly qualified expert witnesses that the judge knew about or should have known about because it was clearly in my pretrial papers. And one was a lawyer that had over 200 trials to verdict, and the other was a former state bar prosecutor. And both of them had given me opinions stating that they were willing to come in and testify that they breached the legal duty and the standard of care to these people. So I told the judge while the jury was out that I vehemently object. An attorney did bring this case. Me, I'm standing in front of you. And our case is premised not only on what I'm trying to present here, but on two other expert attorney witnesses. So there's actually three attorneys that have brought this case. And that went nowhere with him. And when the jury came back, again, the case would fall like dominoes in our favor. So there was a legal duty. They were the attorneys for these people. And more particularly, there was a conflict, and the attorney had a specific duty to apprise the clients of this material fact. And as I said earlier, to tell them that they had the opportunity to seek the advice of an independent counsel, and that the attorney under the rule of professional conduct had to get their written consent waiving the conflict, and they never did that. And so then on causation, based on negligence per se, based on the rule that couldn't be circumvented, and based on the experts that we weren't allowed to present, and the fact that our minimum damages were the $2 million that were offered, we should have at least gone to the jury, and I think we would have won this case if it went to the jury. But this judge prevented that, and he even got it wrong. He came in and said, I'm entering a directed verdict. And this is getting a little technical here, but there are 3 devices to take away the case from the jury. One is a non-suit that's at the close of the plaintiff's evidence. You get to present your whole case. And then the other side will come in and say, Your Honor, we'd like to make a motion for a non-suit. One of the critical elements of their prima facie case is missing. The next device is called a directed verdict, which is at the close of all the evidence. Both sides have gotten to present their evidence, present their case, and then before you go to the jury, either side would make a motion for directed verdict. The defense saying that, again, a critical element of the prima facie case is missing, and the plaintiff could make it saying a critical element of a affirmative defense on one or more causes of action is missing. Then the judge would contemplate that, ask the parties usually to brief it, and there would be a hearing. Both sides get to present it, and the judge would make a ruling on that. Again, these devices are critical because they're taking away somebody's right to a jury trial, which is a constitutional right. And the third device, and some say is the most critical, in each of these devices, the judge is kind of acting like a super 13th juror. And the most controversial is a JNOV, which stands for judgment notwithstanding the verdict. And this is after the case goes to the jury. The parties submit jury instructions based on the evidence, and they deliberate those between themselves and the judge rules on what he's going to instruct the jury. Then the judge will instruct the jury and then will give them the case. And they go into the jury room and then deliberate on it, which is one of the most important things in our society, in our country, is that the jury gets to deliberate. The jury is the law that day. They are the community. And they then exemplify the first 3 words of the Constitution, which are "we the people." And I'll just digress for a minute. We the people start out and we give the power to the government. And it's with our consent that they give it, and they're supposed to act honorably and take these oaths of office and do their duty very diligently. But the question is, once we give this power to the government, how does it come back to us? And we're supposed to have checks and balances through 3 separate co-equal branches. But what happens most of the time is these branches, instead of acting independently and watching, heard, and holding accountable the other 2 branches, they usually side with government and against the people. And so there really aren't checks and balances. They're illusory. They're defunct. And so the question then, and when this starts to happen, like the Declaration of Independence talks about, a long train of abuses, and that's what's happened in America, that little by little these abuses have happened, and government has gotten more power and less accountability, and the people have gotten the shaft. So the question is, how does the power come back to us? What are the real checks on government if the other branches won't check each other? And there's 4 vehicles. One is sitting on a trial jury. Another is which is also called a petite jury. The other is sitting on a grand jury. There's voting and the right to petition. And those could be bulwarks against tyranny. But in fact, those have also been watered down, like the 3 branches have been watered down, and their failure to hold each other branch accountable. When the courts have interpreted these fundamental rights and vehicles, they've sided with government and eroded those from us, and they largely don't work. And I'll digress for a minute here also. Again, the Constitution starts out, "we the people." Well, that's been changed to "we the government." Then there's 3 founding principles of our government. One is that we're supposed to be a government of limited and express powers. Well, nothing could be further from the truth today, because the federal government is anything but limited. The federal government is a cancerous behemoth, and it just keeps metastasizing. Taking more and more and more power, and unfortunately too many times we the people have also been uninformed and haven't been diligent, and we even vote them more power sometimes. So that principle is out, limited government. Number two, we're supposed to be have a written constitution and be a representative constitutional republic with a rule of law. But what has happened is the rule of law has been trumped at almost every turn by politics and corruption. And the third thing is we're supposed to be a representative republic. The the legislature was placed first in the Constitution for a reason. It was supposed to be the branch closest to the people, that we, and most particularly the House of Representatives. The House of Representatives is the most important institution because it's supposed to be the pulse and the lifeblood of the people. Our representatives are supposed to be one for every 30,000. That's in the Constitution. And in fact, General Washington said, one rep for every 30,000 people, we have representation. One for every 40, we have tyranny. And so what has happened is that, let me digress for a second. De Tocqueville came over here, and he marveled at our House of Representatives, how the people in their communities could talk to their representatives and inform them of what their concerns were, what were the problems, and what were their issues. And they could talk, and then the representative could go back to Washington, carry their water, carry their concerns, and then they would debate and they would solve problems. And so what's happened in this country, I forget exactly what year it was, but it was around 1910 to 1920, somewhere in there. The House of Representatives was capped at 435. And at that time, our country had about 125 million people. So since they've capped that, our country has gone from 125 million to about 310, 15, maybe 20 million. But we still have 435 reps. So what's important about that is, since 15, when they capped the House, we have had ever diminishing representation. And now in some House districts, there's one representative. Instead of 30,000, it's 1 to 800 or 900,000. Now they tell you, write your congressman. Do you think you're going to get a reply back if you're one of 800, 900,000 people? These representatives also sit on several committees, and they're also subject to money and lobbyists in Washington. And you can write them usually until you're blue in the face. In fact, my own personal experience is, on some of the times I've sent emails, I get a reply back, and the reply has absolutely nothing to do with what I wrote about. It's some perfunctory PR thing they want to send out. And that, in fact, is worse than them even not replying, because what I could assume something went wrong if they didn't reply, but when they write back about something that has nothing to do with what I wrote them about, they're proving to me that I don't matter, that they didn't hear me, that they don't represent me. Now the other thing is that the other two branches have grown inordinately while we have capped the House of Representatives. First of all, the judiciary has grown in leaps and bounds. In fact, there are twice as many federal judges, or over twice as many federal judges than we have representatives. So what has in fact happened, the judiciary that was placed third in the Constitution for a reason, it was the least powerful branch and was said to actually have no power. Its true power came in its reasoning and the wisdom of its decisions. The least powerful branch, the third, has now leapfrogged over the first branch, the legislature, and now everything ends up in the courts and we have judicial supremacy. And also the executive branch that was somewhat connected to the people because we vote for them. We don't vote for the federal judges. They're appointed, it's not for life. It should be good behavior, but good behavior has no meaning anymore. And I'll get into that if I have time, as to the lack of accountability of the judiciary and the lack of holding them accountability. But as to the executive, it has grown in leaps and bounds. And one thing that's very, very critical right now is President Obama has at least 32 unappointed czars that do not come before the Senate for confirmation, and most of those confirmation hearings or just political backroom deals anyway, similar to the federal judges. So back to that case, and what happened there is the judge ignored my arguments, and I did get to talk to some of the jurors afterwards, and some of them were shocked as to my explaining to them what actually happened there. But we're in danger if our citizenry do not know the tremendous duty and obligation they have as citizens. Freedom, liberty is not free. And what's happened in America is most Americans have become tourists in their own country, and they've taken a permanent vacation on their civic duty. And they just think that the government's going to look out after their interest and do the right thing. Well, we know that's not true almost on a daily basis. And so we, the people, it always falls back on us. We are the biggest bulwark against tyranny. Our Constitution is the only thing that separates us from tyranny. But the Constitution, although being a great document, just like the Declaration of Independence, they're merely pieces of paper. And when there are incursions on them, we have to fight that. And our representatives and the branches of government have not been doing that. They've let government have largely free rein to get more power and to largely abuse us in too many ways. So back to the trial, when the jury came in, and I talked to them afterward, and it wasn't over because we came back, and then the judge said, you're coming back for a sanction hearing. I was threatened by this judge that he was going to sanction me $165,000, or at least that's what the other side was asking for. And by this time, I readily thought he was in their pocket. And I couldn't get the press to come down and have ever done anything on this case, but guess what? They were down there that day. And I did talk to the press afterward, and I informed this lady, I have a lot to say to you. But this was after he had set up the sanction hearing, and I said, I have a lot to say to you, but I'm not ready to speak now. This guy is crazy. The law means nothing to him, and so I'm not going to say much at this time. And I'd love to talk to you when I'm out from under his power and abuse. And of course, then I went back later and she wouldn't write anything. She did write an article after that event, and she did write another one after the sanction hearing. And I don't know if we have time to get into that, but that was another debacle in several ways. And the judge proved he had no idea what he was doing as a judge. And anyway, we got out of there with no sanctions, but somewhat embarrassed by the media, their false and inaccurate reporting. You want to stop for a second here?